Okay, let's start with this. Thank you for coming, Chris. This is a position of the Basic Law Institute in respect of the U.S. Hong Kong Policy Act, which is now being threatened to be revoked or repealed by the U.S. Congress, according to the U.S. State Department and their president. And the allegation is that the enactment of national security legislation by the central government for Hong Kong breaches the Joint Declaration, and that it undermines Hong Kong's autonomy completely, and that as a result they are withdrawing the special status afforded to Hong Kong because of promises that were made by China back in the Joint Declaration, and that Joint Declaration was registered with the United Nations. Now, can I just point out a few factual matters which there should be no dispute. The Joint Declaration was signed in 1984 between Britain and China. And in the Joint Declaration, it makes no mention of national security legislation. But that doesn't mean that the subject wasn't discussed. Because after the Joint Declaration, which largely dealt with broader principles of the one country, two systems concept, in terms of how China will administer Hong Kong, which they say will be in accordance with the basic policies. And the same was then enacted into a basic law, hence basic policies, basic law. Now, further discussions on various subjects were discussed, literally going to every article of the present basic law, after the Joint Declaration by the JLG, the Joint Liaison Group. And it went all the way past the handover to the year 2000, before it was disbanded. And all these records are kept by the British government and the Chinese government, and I believe also by the Hong Kong government. Now, the first thing that, as I said, the facts that needs to be pointed out is that in 1992, the US Congress passed the US Hong Kong Policy Act, largely to support the solution of the Hong Kong situation in terms of the 1997 question and how that matter is resolved. And that was resolved by both countries through the Joint Declaration. And the US government, in support of the agreement, then entered into a bilateral relationship with Hong Kong, hence the US and Hong Kong Policy Act. And largely it deals with matters of trade. And that formed the basis of Hong Kong having not just a trade office in Washington, but also a US commissioner to deal with matters covered by the US Hong Kong Policy Act. However, that was superseded in 1995 by Hong Kong actually becoming an independent member of the WTO. And largely the matters covered in terms of trade in the US Hong Kong Policy Act is now taken over by WTO in terms of the same area, because it becomes a multilateral trade agreement by reason of the most favored nation clause. So it doesn't matter which member. If the US and Hong Kong has a policy act, once Hong Kong and is as a member of WTO and America is a member of WTO, it has to extend to all other members the same trade privileges. It's called the most favored nation clause. Now, so basically, technicalities aside, whether you call the WTO agreement overtaking the US-Hong Kong Policy Act in terms of those areas of trade covered by WTO, so that it becomes from just a bilateral agreement between Hong Kong and the US, it becomes a multilateral agreement between Hong Kong and all the other member countries of WTO. But we must remember very clearly, the WTO recognizes our custom borders, not looking just at sovereign borders. Right? So that's why there needs to be custom clearance between Hong Kong and the mainland, right? Because we're a separate customs territory. Now, so it is really extremely inaccurate and untrue for the US government to threaten the Chinese government and the Hong Kong government with sanctions and with withdrawing or repealing the US-Hong Kong Policy Act, because there's nothing to repeal. It's a multilateral agreement under WTO. So the only question is, by this exercise, is America is signaling its intention to breach its WTO obligations to Hong Kong under the WTO agreements. Now, that has to be put very, it's nothing that you gave to us that you can take away. It's something that we share in the world order on trade. And if this means that they are going to breach the WTO agreements, then let's call a spade a spade. I mean, America's already withdrawn from WHO, World Health Organization. I mean, is this the next step, by not honoring WTO agreements, to them withdrawing from WTO? And that's not an immediate concern for Hong Kong at the moment. The question for Hong Kong is, where does it stand in terms of international trade, in terms of what one country, two systems have provided for Hong Kong? Right? Hong Kong, as I keep telling people, is not North Korea. It is a very open society. A lot of people live and work in Hong Kong all over the world. It's nothing so secretive that needs the US government to now expose the rest of the world about the state of affairs in Hong Kong. Right? Hong Kong is an open book by the day. Right? Anything that happens in Hong Kong receives international coverage. Right? So, as far as the question of the national security legislation is concerned, why is it that China, out of 194 countries in the United Nations, cannot have national security legislation in a territory that belongs to it, which is Hong Kong? Right? If the argument is, but this is what is under the basic law, Article 23, that China has led Hong Kong of its own initiative to pass national security legislation and deal with it. And therefore, it has, as the argument goes, irrevocably, delegated this. So even if Hong Kong never enacts it, there's nothing you can do. I think it seems to be the argument. Right? But that is not true. Because, number one, the John Declaration did not touch on national security at all. The only part in the John Declaration was talking about the freedoms that Hong Kong people enjoy to continue. And these freedoms are under the international covenant. And when it comes to the international covenant, there's always a restriction, universally, a reasonable restriction expressly provided for national security. So that restriction is something enjoyed by the British government, American government, Canadian government, throughout the world. Countries enjoy that in order to safeguard national security. Now, when this was not expressly discussed, so the international norm is therefore what happened in the John Declaration, that what every other country enjoys in terms of its national security laws being a reasonable restriction on fundamental freedoms. That is something which is incorporated in the thinking in the John Declaration. Because if the British side has said prior to 1984, oh no, we think that China can only take over Hong Kong if you do not exercise your right, which I don't think anybody dispute, for any country to enact national security legislation for the whole of the country. I mean, China is not the first to have one country, two systems. Canada has one country, two systems. Quebec has a completely different system. French, continental law, even the language is different. Right? Even the culture is different. Right? And yet national security legislation is the same throughout Canada. Right? So this is something very exceptional for a country to say that one part of my territory will not have the same type of national security legislation as the rest of the country. And why should that be? Now, because obviously it creates a vulnerability in national security, because what you can't do in one part, you can do in another part. When the Joint Declaration was discussed, there was no intention on Britain's part to stifle China's right to enact national security legislation in Hong Kong. In fact, the idea of Article 23 never came from Britain. It was something that I can lay witness to, because it was really the legal profession when we were consulted by the British Foreign Minister Geoffrey Howe, who came to Hong Kong and actually met him physically. And we made our case to say that, is it possible to have national security legislation, right? The main point is not just enacted in Hong Kong, but subject to Hong Kong's common law jurisdiction and procedure. That is the major thing of Article 23. Nowhere in the world will a sovereign government, whether it be the federal government like in the US or a central government like in China, nowhere in the world would they allow a district level court to deal with a national security offense. In America, if you commit a national security offense, in whichever state, California, take an example, it will be the federal court that will deal with you. So it will never be the district court, because it's a federal matter. It's a matter of national security. So in terms of legal principle and international law, China is well within its rights to say that after the 1st of July 1997, the national security laws in China, in the mainland China, will also apply to the SAR of Hong Kong and Macau in 1999, and that the Chinese courts will deal with the matter in terms of law. But because China is very sensitive to Hong Kong's population's affinity for common law, that it was such a bedrock for Hong Kong for 155 years, that they saw that. And they saw that the common law is a major asset for Hong Kong being an international center, because it provides the framework, right? That's why we're more attractive than other countries, for example, like even Malaysia or Singapore or India. They all have a common law type system. But Hong Kong's common law system is so open and independent that it really is the bedrock. And the Chinese government sees this, and they don't want to interfere with it. I mean, what's the point of saying one country, two systems, when they could say, well, I'm sorry, it's just going to be one country, one system. What are you going to do about it? Right? In 1984. Right? Is Britain going to go to war with China like it did with the Falklands, with Argentina? Right? So it was clear that and also that China has made it very clear in 1982 when it amended its constitution to allow within its country systems which are not socialist, in fact, should not be socialist like in Hong Kong. Right? And one of the reasons for that is because of the unification of China, that they're prepared to adjust the traditional thinking of one country, one system, which is in most countries, but to have, sincerely, one country, many systems, Portuguese system in Macau, British system in Hong Kong, and Taiwan's own system, because it wants to achieve right, unification of the whole of China. It is not eager to just exercise control over these places. Right? It wants sovereignty, right? In order to complete its Chinese dream of a unified country, country which traditionally has been held to be part of its people's language and culture and so on.